And this is outside of the dwelling house. What is being contemplated is a
Yes.
dual system of entry. One on which notice is given of at least 24 hours. And the other is by virtue of a warrant.
Investigating a contravention or suspected contravention of the Act.
Yes, very well. Members? Proceed.
All right, clause 145, and I have to say, part of what we're doing is trying to put down the policy. We know this whole part needs to be restructured in terms of how the information is put in. We're just trying to give the information. All right, upon entry, an usher officer may do all or any of the following: inspect, examine, and we are amending 145, but some of it is still contained there. Inspect, examine and make inquiries at the workplace, inspect a document at the workplace and make copies of or take extras from a document. We were trying to tidy up because 145 had said, inspect and examine anything, including a document at the workplace. If copies cannot be made or extras cannot be taken, the document can be removed from the workplace by the authority and returned within a period not exceeding 48 hours. In this, we're trying to put in a time frame because the bill actually left it open-ended, that they could have just kept the document. While the authority retains custody of a document, the person who produced the document, the owner of the document, or a person authorized by such persons are to be permitted to inspect and make copies or take extracts of the document at all reasonable times. And this is taking in some of 149 because we're merging the different powers of entry.
Chairman, we had a
Mr.
concern.
Bosco, yeah.
We had a concern about just the language in paragraph 10, and we noted that the ministry said generally they would refine it, but we would like clarity regarding when the authority takes documents and copies, and you have that requirement that the person who you took the document from can copy or extract. So it seems to be a bit of an inconsistency, because if the authority can in the first instance copy or take extract, why are you removing it? So perhaps the ministry had a scheme in mind.
Very well. Ministry?
Yes, what we were contemplating is in a circumstance where a copy cannot be taken of the document, one cannot be provided to us by the PCBU, and we're unable to copy, that's the circumstance which we would remove it from the workplace. Apart from that, I know the bill spoke to keeping the document, but we were saying if we can actually make a copy, take extracts where needed, then we would not need to remove the document. So it's only where that is not possible that the document would be removed.
Chair.
Yes. Yes, Member Campbell.
I don't know. Looking at the provisions of the Data Protection Act, and here's I noticed that Suljan widened her eyes. I'm not sure what use could be made of any copy or copies made of these documents. And the question arises in my mind: if there is no, the case would not be advanced in any way by just taking the, unless you have that residual power to make use of the contents of such documents. I'm just my observation here.
Yes, Sergeant.
And to add, so you're correct, Member Campbell. There's a little more fleshing out to be done. Also, you would have to indicate if you're taking it. It's usually when you take the document, there is also a purpose. You retain it for a period. So sometimes, depending on if you took it because you're going to perhaps say initiate or have prosecution or some action, normally then you would put in the law that it would be returned when the matter has been concluded or at some specific time. But you have to indicate when you're going to return it, because there have been issues, especially with business documents, when people have removed originals, that persons have issues thereafter. with the tax authorities, with a number of other entities. So you have to be very careful about removal, and then when you are going to return it, and you really should outline it in the law. It shouldn't be a guesstimate.
I see also, Chair,
Yes.
that the intent to import from the Fisheries Act, the definition of document.
Yes.
I see then, and is that the best definition we have?
It's also from the Evidence Act.
Actually, we were going to suggest using the one in the Evidence Act. There are two different ones, but the one here is not quite, it's not exact as what's in the Evidence Act, and we're now in an effort to try and streamline everything.
Yeah.
So,
The one in the Fisheries Act comes from the Evidence.
Perhaps we could have a look at the Norwich Pharmacal case,
Yes.
and see what definition is set out there, because it does sort of give us this very broad band, and we could use that as a model.
Mrs. Seeley Brown, yeah, we have a comment? Yes. Oh, so you're making checks to see. Yes, Aldrin. Yes.
no, so
The ministry is guided by a certain comment would have come from the AG's chambers.
It was at the time when we were looking at labor officers and the document, the term, they had the same powers of labor officers at the time, so the whole document had come in. So at that time we said we would have taken, based on recognition of AG, the Fisheries Act definition, but we look at evidence. But we kind of looked at it, looks similar, but when we looked at Evidence Act, because we did see the definition, I think they're the same, but we'll just double check just to be clear. Yeah.
Okay. Very well. So there's no issue with the definition. Member Brown, you had a specific. All right, very well. Proceed, Minister.
So I was also saying, apart from the definition, in looking at the similar provisions in relation to labor officers at the time, the AG had recommended that it should be made clear that the PCB is not under duty to provide any document which is subject to legal professional privilege, and the officer has no power to inspect or copy medical or personal documents. So we were trying to look back and incorporate those comments here, in that the provisions at the time were similar, unless AG has an objection.
Member Skeffrey, yes.
Just a clarification here. The authority has no power to inspect or copy medical or personal documents. Fine. However, the authority is to be empowered to inspect or copy such documents where it receive the worker's consent. No, if it's not, so it's conflicting to me. You have no power to inspect the personal documents, but the worker can only give consent to his or her personal documents. So if I have absolutely no power, then how can I be seeking consent? Because it can't be general documents or record, because the worker in that workplace.
Or you have power where there is consent.
No, that's I'm seeking clarity. Because it's clearly stated initially no power.
Yes, that's my understanding. But yes.
Unless you have got
I'm seeking clarity.
Well,
so you might
so
understand it one way,
yes.
but we're here to help each other.
Yes.
and that's usually the scheme where somebody could give consent for their own records, because it may be in their own best interest as well. So, but if they don't consent.
So is this word in the best way? And we're seeking
No,
clarity.
as
it's
Minister
a
said,
general,
they've
okay.
just been putting the thoughts.
Okay, so the intent, I understand the intent, but this word,
Exactly.
okay.
But Mrs.
Thanks for the clarity.
Chair, there are two types of documents. There are two types of documents that may be reviewed. One, the documents belonging to the workplace. And the documents now that would be of the personal nature to the employee. And I recall us, during one of our deliberations, making reference to taking the personal records of the employee with consent. So should there be a distinction in terms of how this is written to establish on the one hand that you're treating with documents referencing the employer, Give you an example. If they have a code or guideline or procedure in relation to occupational safety and health, so you'd want to reference that. But on the other hand now, the worker's personal record. And so the worker must be given the right to provide consent. And that it being the only way you can get it. But there has to be a distinction in terms of how this is written.
Thank you, Union Man, for helping out.
Yes, Member Longmore.
Yeah, Chairman, I'm not sure if it is provided for elsewhere, or we would also consider at this point where the disclosure of such information or access to such information may not be recognized by the individual themselves, but an overarching governing authority has to see to the betterment of even the same individual. So like in the Mental Health Act, where someone is violent secondary to their mental illness and is deemed a risk to themselves or others, we can intervene with respect to protecting themselves or others or the public interest, etc., etc., if we are making provisions for that also in terms of access to the information.
Ministry? Yes, Ms. Michael.
I'm thinking that firstly before the ministry could, I don't know if that could be something that is placed in the legislation, because certainly firstly the authority would have had to have some documentation to suggest, to indicate the person has this mental health issue, and it would be based on whatever that documentation is, and if there is consent given by somebody else.
Not a mental health issue, no man. Mental health issue deals with self in and of itself. I'm speaking in the context of the work environment and the access to documentation that we are considering generally. In terms of where, I can't.
So are we talking about documentation at the workplace?
Yes. Not necessarily in the context of mental illness, because that is already provided for under the Mental Health Act. I'm just saying in the event where in this, as we're contemplating ability to access information and how to go which officer, etc., etc., if there is a superseding situation where maybe for public interest, etc., that information, it commandeers access to that information, it is granted.
Chairman.
Yes, Member
There's
Brown.
a fundamental difference between those who have diminished mental capacity and those who are deemed to be sane. And those who are deemed to be sane are the only ones who should give up of their rights. The diminished mental capacity is accepted as requiring a guardian, be it the mental health officer or some other person. But I don't want my brother or even myself saying be treated as if somebody explained to me once that Freddie said MTR, right? I wish to be treated that I'm not MTR.
But
it baffled Dex.
Yes,
the mental health
I think the
expert
point you're making is
when
that...
he said it, it baffled the mental health expert too at the time.
Yes.
But being the person he is, he explained to them after what MTR.
Well, what I will pick out of what you have said, Member Brown, which may be of some relevance, is that if a person is mentally challenged, then within the spirit of these discussions, that person cannot give consent. And what is contemplated here is that in circumstances where somebody is mentally sound and fit so as to give consent. So, proceed.
So we agreed to reword the last paragraph of B to make the intent clearer. So the rest of these provisions are coming from 145. So C in the bill, bring to the workplace and use any equipment or materials that may be required. D, take measurements, conduct tests, and make sketches or recordings, including photographs, films, audio, video, digital, or other recordings. E, you have a comment? We can use the word document for all of this. The Solicitor General has said we could use document, would have covered all of this.
Okay. Very well. Proceed.
All right, take and remove for analysis a sample of any substance or thing without paying for it. And that is in the bill also, 145(1)(e). Require a person at the workplace to give the USH officer reasonable help to exercise the USH officer's powers under paragraphs A to E. And G, exercise, I'm going back to the bill, exercise any compliance power or other power that is reasonably necessary to be exercised by the USH officer for the purposes of this act. I've gone back to the... And I think the Solicitor General had said reasonably necessary. Why I went back to the bill is because since we have gone back to USH officer, I didn't need to reformulate.
Very well.
Chairman, I'm a little concerned about E. Take and remove for analysis a sample of any substance or thing without paying for it. It's very wide. So you could go into or it could be an office where they're conducting experiments, some scientific thing or whatever, research. It's too wide and it needs, so I understand what they are probably trying to get at, that, you have a health risk and you need to sample something, but there needs to be some parameters, and it has to be a little more reasonable than what is here. Because I also know why they put without paying for it, because of what it could be. Yeah. I suggest that we put some thought into it. I don't have the answer for you right now as to how this could be. I think there has to be some restrictive language put to these very general words. I can't tell you, I don't have the answer right now, but I would like us to at least square bracket this and come back to it.
Member Gill?
My first concern was when I saw the word any. Any. It means it's wide. I can take absolutely anything, even if something is under research or, in its incubation stage. I can take it for sample.
Yes.
Two about challenge, because as I read it, I underline it. First of all, you take a sample, it doesn't quantify the sample. So you could take 3/4 of the whole I have. And so after you would test and there, you found no problem, my business crash. No, because it doesn't quantify the sample. And then it doesn't state how often you come for the sample. So you come for the other quarter next day. And therefore the population gone. So we have to be careful how we just put it loosely, and then paying for it, we understand the context. So there has to be some conditionalities put to that. Also in terms of those, you can take any use of any equipment and material into the workplace. But I mean, what level of supervision or observation the employer has? Because I could take an equipment to gather information, but at the end of the day it's not compatible with my system, there's damage and so on. So even while you're doing your work to investigate and you take outside equipment, what's my right and responsibility in all of that? Because you're investigating, you have not charged me, I'm not found guilty. You could just come in as the OSH officer and your normal work. And my organization could at the end of the day be okay, but you bring in your outside equipment. We're talking in the days of technology with virus in the virtual world, and after you leave, my system crash. What recourse do I have? So while we understand the need for safety in the workplace, balance for both the employer and the employee and the workplace generally is important. So we have to understand that it's not the traditional factories that we're dealing with, you know. So sample can be electronic also. and attaching your equipment can be in the electrical world. So we understand the industrial world previously, but this bill will seek to police all workplace. So while we're moving away from the Factories Act, let's not try to still stay in that position with some of these clauses. Think about the new world and the new order, the technological world. And so people have their laptop, for example, and you can't put a flash drive in my own because we know what could happen. So we have to understand some of these things. And if an employer resists that, there's a right to so do because of the consequence that could arise after you leave. My entire data crash and I lose all my information. For example, Lawyer Campbell, somebody wants to capture all the data and I bring my flash drive and put it in your system. And after they're gone, you lose all the file. So these are some real things we have to think through as we put in this new bill. So while I understand the intent, the wording has to be clear and to give balance to all the parties.
Minister? Senator Brown, you wish to say something? Yes.
It says essentially that you can seek the assistance, but strike me as more than seeking the assistance. Require a person at the workplace to give the OSH officer reasonable help. What if I don't want to? Are you going to compel me? Is there a pain of punishment?
Yes, in 145(2), there is a penalty.
Okay, but for the record, I think I just have to say we don't agree with the use of the word require.
Yes.
So it's normal to say to seek assistance. It's usually along those lines. Just that you may need some help from someone there, and you should be able to ask for that help. No, you can't comply. No.
So F is to be reworded.
I'm also not sure now about sub 2 because it didn't create a penalty. So I'm not even clear on
Yes.
I'm not sure on the intent of 2. I'm not saying it should be a penalty. I mean a offense, but it didn't even create an offense. So it's. I'm not, as I said, I'm not clear on the intent of 145(2).
If it is relevant at all. Yes, Minister.
3 to Soldier, go to 3 as well. You put a burden of proof on the person who refused to help.
Any comment, Minister? I guess you have picked up the mood. Yes, I think. Yes. Yes. Yes, that entire scheme will have to be looked at. But let me hear from you, Minister. Yes. So I think what is being contemplated is that we will reword F and consider deleting subsection 2 and 3.
I think there's an error there because normally we use this when we're setting up a criminal penalty if you look throughout the bill. So it looked like a criminal should have been there and it's not there, but we won't go that route. Because that is how we have been setting up the criminal so far.
Yeah. What you'll require though, if you're going to ask somebody to assist is to provide protection for that person who might assist. If you're dismantling somebody's machine, do we give indemnity to the employee who assisted in dismantling the machine or in removing the goods pitch sample from the workplace? And what if the employee is disciplined elsewhere for assisting? There's no protection in the legislation for such a person.
We dealt with it under reprisals some while ago. Remember, we had a whole provision in relation to reprisals under this legislation, so that was where that would have been contemplated.
So this would come under that?
It would have been, those are sort of actions in reprisals that would have been protecting the worker.
All right, cool.
Our Ministry, do proceed.
We're deleting 2 subclauses 2 and 3.
Members, we agree? Yes. Paragraph 11. Yes, sir, ma'am.
146. A person, the assistant, including an interpreter and a police officer, may accompany the USH officer entering a workplace under section 143. I'm reading from the bill because we're no longer making the change with the authority. To assist the USH officer if the USH officer considers the assistance is necessary.
Right, but I have a concern with 2B, that the assistant shall not do anything the officer does not have power to do. You cannot limit the powers of a police officer because one of the persons will be a police officer. A police officer has common law powers and powers under law. If a police officer goes somewhere and sees something, the police officer is under a duty to act. If you have brought in a police officer, there must be a reason you did that. And you can't limit, and I can't agree to a law like this limiting the police officer from exercising his or her powers that they have inherently or under the Constabulary Force Act. So I can understand it though for like the interpreter, or if I'm assuming the interpreter is someone who is going to interpret.
Sign language, persons with disabilities. But I'm wondering if we should just take out the police officer then out of this provision, because you would be able to get assistance with the police officer without putting it under this legislation.
What was the original intent to have it there? Behind the policy?
Well, just to give an example of the kind of persons who we were considering assistance.
It says including.
No, I understand that, you know. But
So-
you specify that one. So it must be a purpose why the police officer was specified as against the fireman.
Powers of entry, so we realize that we would need it. Sometimes you will need the assistance of police officers in exercising your power of entry.
But given what was said, so why are you now deleting it? That's what I understand. You have it there, so you're in and you're out. So I don't think the Solicitor General was necessarily say you should take it out, but you can't limit it. That's all she was saying. You know. So if you think it was important, then let's reword it to allow the police to have his broad power, irrespective of.
This is C. Brown. There's usually there's a provision we have in some other laws where you can get the assistance of the police to assist you, which is
That's always a tricky still. But like what we did in Fisheries Act.
yeah.
Look at how we did it. Man. Look at how we did it.
Yes. Yes, Mr. Baker, I recognize you.
Here, in our situation, we do not name the police. The police have, his jurisdiction very wide. So we seek the assistance whenever it's needed. When we meet upon a situation that we think may pose any risk or resistance, we seek their assistance, and they always do to help us to.
Very well.
I think that if we're going to put the police there, it should be a separate clause. Sorry, I didn't hear you, but it should be a separate clause than the other. It don't, I mean, this era, and having regard for, let's give them a plug, Black Lives Matters, do we want the police doing everything? And in this, is there a role for private security guards? It may be an hostile environment where you want to take security guards in to assist you and to protect you. So maybe we should couch the assistance in a way that is broader but doesn't treat the police with the limitation that this does. And that may be the route around it.
Sergeant, you're
And then Mrs. Celia Brown found an example, not in relation to the police, in relation to other persons now. So, for instance, it could apply to, say, a private security officer who is assisting. What you say, instead of what's there in B, it's usually said that you give them the powers of the USH officer so that they can do whatever the USH officer does. It just says it in a different way, but that's normally the way that you say you give them those powers. But those would be for persons who already don't have those types of powers. You won't do it for the police officer. No. So it's true that we can treat them separately. And we can look to see, I've heard from the members, from Member Campbell and Member Brown, so we can look to see how it would be crafted. But it would be a little different.
Yes, very well. Minister?
Yes, we're guided.
Very well. Proceed. Yes, you may proceed, Mrs. Bennett Campbell.
All right. Subclause 1 should be amended by replacing the term premises with workplace or suspected workplace. The word sir should be deleted. But this is the JP clause, so I think I'll just read it out. Where justice of the peace is satisfied, and we were querying to the placement because, as you see, things are not flowing because we have gone into the justice of the peace and the warrant here. Where justice of the peace is satisfied by information or an oath by an officer that there is reasonable ground for suspecting that a provision of this act has been or is being or is about to be contravened in or about any premises, and it would have to be workplace because we haven't used the language of premises per se. The justice of the peace may grant a warrant in accordance with subsection 2.
Won't we have to link it back to the first one? Yeah, the very first one, 143. I think that's where we should start. After we've made the distinction as to when you would require a warrant and when you won't require a warrant. So it should come earlier. Yeah.
Right, that's why I was talking about the placement, because we're not having the flow. It should have come nearer when
Yes,
we were entering.
agreed. Okay,
So it was
alright.
just there.
So this is circumstances where a warrant is being, is required. 140.
7.1
Yes.
of the bill is the warrant. And we were saying it should have appeared closer to 143, where we're speaking about entrance in the first place and how you enter.
I see what is being proposed here, the substitution of the word premises with workplace or suspected workplace. Well, I'm going based on what is here. I want to hear you on this matter now. So, yes. Yes. So, yes, very well. We are just allowing the legal team a minute to comment.
So, Chairman, so early in the bill, if you go to clause 9, a decision had been, well, I think it's a decision. I have 17th of June.
Yeah.
29.
On page 3 of our
2019? It can't be 2019. Wow. So this was a decision of the Joint Select Committee.
page 3 of the
June 17, 2019, where we were looking at even, looking at the taking out dwelling house and using premises. So now Mrs. Seeley Brown is saying we have to be careful how we use premises thereafter, because even in clause 9, it's done in a certain kind of context. And then I turn it over to Legal Reform Department. I don't think we can resolve these kind of issues right now, which is why, remember, we have to just note it and make our jottings, including the day and the year.
Remember, you had given us some initial guidance in terms of when we come up against these things, how we treat with definitions later on. And so we learned from that.
So we're going to defer what is being proposed. Yes, which is really to substitute premises with the words workplace. And yes, so we're going to defer that. Ministry?
No, and at 147.2 though, Chairman.
Yes.
147.2 is loaded, not just about premises, but we come back to seizing things and detaining and criminal offenses. Sorry, I'm looking. If need be, if need be, yes, it's there. It's really loaded, and I don't know if the discussion we have had want to retain all of this. It's some strong languages, you know.
The ministry was
Ministry,
asking for a
yeah.
deletion, actually, of subclause 2 in this document.
Yes.
Can delete that because remember we've set out the powers
Okay.
earlier of the OSH officer,
Yes.
right? So we don't need to. This can be
Yes,
deleted.
very well. So what is being asked, members, is that we delete subclause 2 of section 147. Aye. Proceed, Minister.
I have been asked by the ministry to query if in this circumstance, if it is possible that we, without contravening the Constitution, for us to have gotten the power to enter without giving notice in this circumstance. I know we have gone with the warrant, but
I think it's a request that is going beyond the dwelling. Yes, I think it is, you know, I know we'd have discussed in terms of the dwelling house this morning and the need for the warrant, but I think what the ministry is asking now is, other work, please.
when you're in relation to contraventions or suspected contraventions, would it be?
I'm thinking if we're going to do that, Esther, correct me if I'm on the wrong track. You're going to have some sort of condition where you reasonably suspect that some risk or something or some injury, whatever is happening, is imminent. Then you may without notice, but you're going to have to qualify it with a condition. I think that's how. Yeah.
Yes.
At no point, Mr. Chairman, should we contemplate the entry into any place without the appropriate authority to do so. So, you know, the warrant is something that you make a declaration that this situation exists, and you're issued the warrant to protect yourself overall. So, no, you know you don't have to give notice, but you're going in with a warrant.
With a warrant.
Yes.
It's not that you're giving notice to the person, but you're going without. Okay. Okay.
Yes. Yes. Yes.
Call that we're also coming with that tier system of notice and that kind of escalation. So if it reaches a point or the breach is such where it warrants a warrant, then it would kind of be triggered or so, because in terms of adding another layer, you know,
Member Gill? Member Campbell?
That's really an issue. For whatever, once you have the declaration to say that such a situation obtains, then the warrant, without any notice whatsoever, entitles you to enter. But what I wouldn't want to see is a situation where you're trying to enter without having any authority, as it were, in the form of the warrant to enter.
Very well. Member Very well.
I must confess, I can see extreme cases in a residential environment where there's safety risk. But I'm trying to think through bedrooms and living rooms, why we perceive that there'll be risk there. So maybe I could be guided as to, from real life, what is on the real. I can see an electrical problem. Every time I touch a bed, I get shocked. Every time I touch where the
But we're not referring to the dwelling house now, Member Brown. We're talking other workplaces.
No, it's talking about residential.
That's 148, but I think...
Oh, you're not at 148?
No.
Oh, cool.
No, we were just asking a question. We had not gone to 148 yet. So 148?
Yes.
This clause should be
Yes.
deleted and reformulated to state that the USH officer is to be empowered to enter the workplace of a domestic worker with the consent of the person conducting the business or undertaking or under the authority conferred by a warrant.
Members? Yes, Member Gill.
So in this case, you would have to have the warrant to be able to, for access at all times. And so the warrant or consent, but to turn up with a warrant suggests that you don't have to give notice, right? But for you to turn up with a warrant, that warrant must be supported, in my mind, with some reasonable cause. Yes. No, as the owner of the dwelling house, I would want to be, that's what they're going, you know, residential purposes.
148.
148. No.
No, I
She
think
just
we have moved on.
She just read 148. So that's where my mind has gone.
Yes, we're at 148.
I'm trying to follow as slowly as possible. But you'd have to satisfy me that there would have been at least probable cause or reasonable cause for you to substantiate a warrant. That's a JP, and it has to be outlined. You see?
Yes.
We will have to just rework paragraph B, right? Where it says under the authority conferred by a search warrant. But we have to be.
It should be in 147. 147.
Well, yeah, we switch it up. Yes.
So is it that we are saying that what is in yes?
Chairman, 147 is supposed to set out the conditions for the warrant.
Very
So it
well.
would go into a little bit more,
Okay, fine.
but it needs reworking
Reworking. Okay, very well.
so that we can satisfy Member Campbell.
And not just that, but we then won't
Have to go into a lot now afterwards.
for residential purposes. Yes.
Very well. Okay, very well. That's clear. The conditions, yes. Yes.
So it sets out a lot of the detail in terms of the conditions of the warrant. So it would explain why you go to a JP and what the JP is supposed to be looking for. If it does all of, and it will usually, it says something like it can give a lifetime, like it will tell you how long the warrant is for, how it can be executed. So there are a couple of things that usually put in. When you set all of that out in 147, 148 would need to go into too much now about the actual warrant. It would just say you use a warrant, but it wouldn't have to again go back through. And then I guess 148 could also then say either the warrant or the consent of the person. I have a little issue with this thing of the consent of the person with management or control of the place. Now with a house, with a home, who has control? Well, this doesn't say owner. This says person with management, and then it has control. It's suggesting it's two different concepts. Now, the owner could be the manager, but who is the person with control? The gardener?
Yeah, but the owner in this case, let's say you own the property, but you rent it. And so you have you never have control over who is the tenant who may have employed the household helper. Exactly. So in this case, management or control, in my mind, would have to be, explained. Remember,
Ministry?
we spoke about earlier in the establishment or the workplace, the owner who is in charge, who might be a foreign.
Yes, earlier.
Yeah.
Yes,
Right?
1 year ago.
In this case, you may own the thing, but you're not there, so you don't have control.
All right, let me hear from the ministry before you come in.
But to add to that,
Yes.
I may own the place and I am here, but it's rented, so I don't have control. I didn't employ that domestic helper, for example.
The tenant is the owner.
The owner in this context is who is living there.
The tenant
and who
is,
does the employment.
The tenant is the owner for the limited period that he's there. So once ownership is.
All right, Mr. Simmons, I'll hear from you then the ministry. I know the ministry has something to say. Mr. Simmons.
Yeah, Mr. Chair, it may be the opportune time to return to whether or not you want to use the term PCBU, depending on how you define that. Because we had moved away from that term.
So you are saying it may be appropriate?
Well, I think they need to go back and all of us need to look at it, but PCBU maybe, since we're now back to workplace.
Yes.
We had departed from it when we were talking about establishments. We may need to go back to PCBU.
Very well. Minister?
I just want to bring everybody back to number 13 on the policy paper. We had those kind of discussions, and because of that, we were using person conducting the business or undertaking. The amendment says the clause should be deleted and reformulated to state that the OSH officer is to be empowered to enter the workplace of a domestic worker with the consent of the person conducting the business or undertaking or under the authority conferred by a warrant. We had those same discussions about in relation to the household, who is the person with management or control. So we had actually moved away from that language. And we were also deleting C for clarity.
So we have gone back to the person conducting the business or undertaking. Yes.
Vague, sir.
Okay, well, let me hear from you, Mrs. Seeley Brown.
That we're speaking here to, even though we speak of residential purposes, we're speaking to domestic workers, because remember when Mr. Simmons took us back to that definition of home worker, right? And homework is carried out also in a place of residence, right? And it's not, yes, and it's defined separately and differently to domestic worker. So I am not convinced that that is what we're speaking about here. So when we go back to the definitions, these are things that we're going to have to clarify, Chair.
Very well. Very well. So 148 is to be reworded. Reworked. Yes.
There's a question here, though, Chair. Word.
It's to be reworked, yes.
I know we want this bill to be as comprehensive as possible and to capture everything, but with the best of intention, that's sometimes impossible. And I'm just saying, given that this is a new bill, could we exempt that provision for the time being and see how best we operationalize it for the workplace in a general way as we have it? And then when it comes to a period of review, then we could determine assess how best we have implemented the bill, and then how we can broaden the scope as we proceed. Because sometimes we might be careful, we want to bite off more than we can chew, and we might end up not being as effective as we want to. While I have absolute respect for domestic help and understand that they are also in danger when it comes to their own health and safety. So I never seek to ignore that. But, you know, to put every piece in this legislation, we might end up not being able to be effective when you come to operationalize it. And that's my thinking. So sometime a phased implementation as you go on will make it more effective. So that's food for thought as we look at it also. If it can be reworded to capture it, I'll be great. But if not, I will still detain myself at that section and we move on. I don't mean today, no, as we revise it next meeting.
I want to agree with Senator Skeffrey. I raised the residential thing earlier. I don't know what are the risks that we're trying to tackle in a residential environment and so forth, that we can't tackle through some other means. If it's a public health issue, then maybe that's where to go. This legislation is going to require the fullest of buy-in. I don't want people to be saying, so the law say, them can come in my bedroom. I don't think we're going to have a lot of cases of going into people's bedroom. But that is sufficient to turn off a large set of people from supporting the legislation, because they only need to find one thing that they don't like in it. I don't think we should give them this one on the residential part. I am prepared to take out entry into residential, especially if some other legislation that exists now. It's a public health issue. It's a police issue. But we want buy-in into this, and for that reason, I don't want to push the residential thing to the degree it is in clause 148.
Mr. Baker?
Full agreement with the discussions. Just to say that probably we could divide the entities into different categories, like manufacturing, mining, agro-processing, and other, which will take in like household, offices, etc., of lower risk. I think like for household, we may have to get a policy out of what we are doing to address certain, to educate and to sensitize employers. And one of the things we have to notice about household helpers, the risk that is there to household is there to the residents as well. And plus the household helper, this should educate them to have tools of trade, like their personal protective equipment. That will push up the cost of their doing their jobs. Right. So those kind of things. But as Senator says, senators, it's very difficult to crowd, to pull everything, because we're talking about a mountain of things. And as we were speaking, the Public Health Act the officers enter these premises and carry out certain functions, whether complaints, whether by routine, carry out some functions within certain entities already. So I think evolving out of the Factories Act, we should be coming down from the top, where we have the huge industries, bauxite, to address some of the things in a categorized form, and I will take it from there.
You see,
Yes,
Chair,
Member Gill.
the day that we include a dwelling house or a residential area, it moves it in this piece of legislation in a different direction. Remember, we contemplate workplace and the provisions of safety and health to include those who visit your property. So, for argument's sake, suppose I was to require an electrician to come to my premises. I have to provide the same level of safety. Right? So there has to be a clear distinction in the processing of this legislation to how we treat with the dwelling house, because of our intent to protect the domestic worker. And we agree that that domestic worker needs protection. But it can't be the same set of standards that we apply to a general workplace or industry, whatever those sectors may be, to the dwelling house in terms of the standards.
All right, Ministry, we have heard the comments.
Minister, that is something we'd have to consider some more, but the reality is we also have to look at the fact that we would be putting ourselves in breach of a convention that we have ratified. And if it is that we cannot actually enter, then it may be that this act could not extend to them, because in terms of all our compliance and what we would need to do to investigate, to see the contravention, we wouldn't be able to do that. So we have to look at it some more, because in relation to the notices and so on, seeing that there's a contravention, if we can't enter to facilitate that, then we don't know. So we'd have to look at it some more.
The debate, Chair, is not whether or not you will have access or you will have that reason to enter. But it's some of these, established protocols that is being demanded. Look at 149. Require any person to tell the hush officer the name and person who has custody of or access to a document. Now, suppose, for argument's sake, again, you rent out the place and there's a breach in covenant. And you say, no, but let me see the title. But me rent the place, me don't have no title, me don't have no access to the title. And so all these things that you are asking for.
A reasonable excuse, member.
Are coming, you see, we're the part now. To answer any questions put by the official. Point I'm making is that we're making some demands in the first instance that we might not need them to be there under certain circumstances.
Very well. Well, the ministry has indicated that by virtue of the concerns raised at this level, there will be a relook at the policy, and we will come back. So we can proceed now, Mrs. Benekama, to paragraph 14.
This is speaking to the heading, specific powers of entry.
So it's just a change of the heading there.
Yeah, because remember, we're merging powers of entry into one.
Okay, so we're deleting the word specific power on entry. Members, we agree to that? Yes. 149?
The heading above.
14, yes. Yes, you may proceed.
Yes,
yes, at the top. We're getting to that now.
Oh, I see.
Yes, we're at 114. Yes.
Specific powers on entry, the heading.
Yes, Mrs. Bennett Campbell, you may proceed.
Somewhat of a change again because of the authority and the change to the hush officer. Upon entry, the hush officer may require any person disclose the name of the person who has custody of or access to a document. But this should all be flowing from the whole entry and access to documents in the first place, because we found it was all over the place because we're speaking already about accessing documents. Any person who has custody of or access to a document to produce that document during the exercise of the power to enter or within a specified period after such entry. So either document is produced while you're in the workplace already, or if it cannot be within a specified period after such entry. In relation to C, now what we realize is that C, if you go...
Before I go to C, would the word relevant before document be helpful? Just asking. Yeah.
Mrs. Seeley Brown, you have heard a question from Member Brown?
When we have not seen provisions like this, Chair, what you would usually see is a general provision giving them access to any information, requiring any person to, rather than a specific document or documents. So I'm not comfortable with clause 149 as it is drafted.
Okay.
I think,
Very, very well.
Stand Mrs. Cedar Brown's disquiet. And perhaps you have to take it a little further, because if an employee is at the place of work and you're asked to deliver up a particular document, what right does the employee have to such a document to require him to deliver it up or disclose? Because he may very well find himself in breach of the workplace policy. So I don't think the obligation can be placed upon the employee. It has to be the person who has authority to disclose. And he must have some proprietary right to that information. Well, my observation.
Yes, Soldier.
So this provision didn't take into account the fundamental right of legal professional privilege. It didn't take into account documents that would relate to personal or medical information of even personnel records have to be treated a certain way. It's too general. It really is just too general. And then if you go into C and thereafter, so again, we have to be cognizant that there are criminal offenses under this law. And well, it depends. It depends on the direction of the bill goes. But these provisions that flow after 1C would not be able to be sustained just as they are. Yeah, I don't want to say anymore.
Ministry, I've heard the concerns.
I just want to say though, we were actually, we said the placement should therefore be reconsidered, please see point 10 above, because we were talking about documents up above. So like the personal information and so, we expected that to apply, because what happens is that we're having documents all over. But in relation to, I think the Sergeant is talking to the provisions in relation to interviews. So we will have to reconsider those, which is under 3, I think it's subclauses 2, 3, 4.
Is this for the purpose of criminal proceedings or not? Because these are akin to provisions you have for criminal sanction. These are the kind of provisions, for instance, INDICOM have. Those are not civil proceedings. And if you're going down that line, then you have to have regard to, is it section 14 of the Constitution and all the case law that goes around it. When a person is forced to answer, the person should have representation, what sort of questions they can be asked, the caution that is applied, all of that. There's a big regime around when you're dealing, and to me, an OSH officer should not be wading down that path. It should be someone who is, because if it's criminal, then you're talking about the police.
And I don't need all this.
Or we do have it in other instances like MOCA and INDICOM where they have been given those very specific kind of powers again. But if you are looking at just your civil kind of process, you don't need this kind of regime. It would be it's a much more modified, it's a less intrusive sort of regime. It is heavy-handed.
Very well. Mrs. Bennett Campbell. So clause 149 is to be looked at and reworded.
because we had said that we would leave the prosecution in the hands
If I may, Chairman,
of the...
yes, we are about compliance and all of that, yes, and we want to achieve that. But we can't start off treating our business people and operators as if they're criminals. And that's exactly what we're doing. In the same way we do with civil servants and parliamentarians, you start off on the basis that we are all criminals, and so that becomes a self-fulfilling prophecy. You know, we all, whatever you want, you go get it. And I don't think that is where we are in the modern day. So if in the unlikely event we have a milder version of this, and it happens that people don't comply, then it's time you have the provision where you can whip it up in a matter of days.
Chair.
Yes.
There are some legislations that in order for them to be effective, they are dependent on the support of other legislations. And I make the assumption that wherever this came from, it may have had the requisite support of other legislations that we don't yet have. And so we might be exposing representatives of an establishment to risk. I have seen, and Member Campbell raised it, where I would have seen contracts of employment that suggest you can't divulge any information regarding the establishment in any way, shape, or form. Or else strong disciplinary measures will be taken against you, including dismissal, and you can be sued. So we're asking representatives here to divulge, for whatever the reasons, to an OSH officer certain critical information that only the boss man have locked up in a safe somewhere. It may be asking too much, and I would want us to take that into consideration when you're reviewing this particular clause, 149, as extensive as it may be.
The points have been duly made. Ministry, you can move on to 150 now.
We were asking for deletion because from day one, constitutional issues were raised about this from stakeholders, and I believe the Attorney General's chambers, I'm not sure. Really? What happened is that from day one, from stakeholder presentations, I remember clearly PSOJ, I remember everybody raised the constitutional issues, I remember saw JPS, and so having looked at it, we wanted a deletion of 150 and 151.
So members, what is before us is a deletion of clauses 150 and 151. Agreed? Yes, sir. Yes. Proceed.
So 152. 152 somewhat repeated some of the sections there.
Could you speak a little louder, Ms.
152 was actually repeating some provisions we looked at before, so that's why we were asking for it to be deleted, subclauses 1 and 2, because you would have realized when we're speaking about powers to enter and the powers that could be exercised, we already had these provisions merged there.
So
145.
Is this a deletion then of clause 152? No.
Yes, yes. It has been subsumed under clause 145. We were discussing, there was a repeat in the bill.
Members? Agreed? Proceed. 153.
So, yes. In relation to
clause 153 is proposed to be deleted.
154.
Yes. 153.
153.
Members, the proposal is for it to be deleted. Yes.
I just want to explain though that 153, these provisions here are dealing with the powers of seizure. So as we said to the committee, all of these provisions here are going up to 159. So as we said to the committee, when we bring the provision, how we are treating with the notices, you can look back at it. We asked for deletion now, but when we have looked back at how we deal with the notices, then you can make a final decision.
In other words, these errors will be substituted with some other parameters. Whilst you're going to delete them as is, there's going to be a substitution of how you treat with it.
We have the notices already in part 10, but we are improving on at least one of the notices to cover something else that we may have to delete here.
So it is on, yes. 153 to 159.
153 to 159, those are all the powers in relation to seizure and forfeiture of seized things, return of seized things, etc.
No, so let's follow up on Senator Gale's point, is that these clauses will be deleted totally, and hence you will renumber. So it's not that you will have substituted words for the clause. I just want to be clear.
It would have been deleted. The only one we are trying to work into one of the notices is 154.
Okay.
So do we agree, members? 153 to 159? Yes, but we're going to deal with it in part 10. Yes. 160, paragraph 26.
Yes, 160 was dealing with damage and compensation in relation to when you have exercised the power to enter. So it basically says that the OSH officer should take reasonable steps to ensure, and any person assisting them, that they cause as little inconvenience, detriment, and damage as is practicable.
Any comment from Mrs. Seeley Brown?
No, I like this particular one, you know, because if I come into my place and you remember Senator Skeffrey spoke about, you know, you take sample or you insert your device and you cause disruption, then you would be held liable. Isn't this what this is saying, Mrs. Bennett Campbell?
Yes, because in doing your powers, you're not to be causing damage as much as possible, because you have to look at a balance between the rights of the PCBU and the OSH officer. So you want them also in entering to know that they have to be careful when entering also and exercising their powers.
I wonder when you will be compensated in the event.
But isn't that a general obligation on the general law, not specific to this piece of legislation? So if is it superfluous to then throw it in? Because if I being an OSH officer, I go in and knowing that I have carried out, there's no liability which flows from my taking all reasonable care, and no liability flows from that.
Under this bill on 152, 62, it actually gives the person that they can actually claim compensation against the Crown, and this case would be the authority if you do cause damage.
Member Campbell, please use your mic.
Under the general law, but you want it to be set out there specifically to say, yes, if I do it unreasonable, you know.
When you ask a question like that, the Ministry of Labour is always minded. If you say, do we have to set it out, to take it out? But what we were trying to do is to show some level of balance in terms of the power to enter, to give persons some measure of protection.
No, but let me practical. How you measure that though? How do you measure that? How would you determine that I did not take all reasonable care, but this thing still drop and break up?
Well, what it allows for, if you read, well, let us read the rest of the provisions, because it's actually, there is damage that has been suffered here by the person, and they're basically trying to seek compensation in relation to it. But the court may order, in relation to 162.3, the court may order compensation to be paid only if it is satisfied it is just to make the order in the circumstance of the particular case. 4. The regulations may prescribe matters that may or shall be taken into account by the court when considering whether it is just to make the order.
Chairman, one, I believe that if I was an ASH officer, I'd want some immunity.
Yes.
And I've seen legislation which gives officers immunity. Secondly, when we started this legislation, it was the Ministry of Labor, it was the Crown. Now, this is a statutory body. I have seen the silence of the Sergeant, but it strikes me that the second respondent is going to be the Attorney General. Right? Huh? What I'm saying, I note you are going to be sued. You are going to be sued in this thing as well. I know it binds the crown, but what I'm saying, but Kavan's bicycle shop decides that you damaged something there. He's going to sue. Will he be the Attorney General in this? Everybody along the way, the ASH officer.
A body corporate.
And not the ASH officer. And by the way, where you all get your money again from? Where you all get your money again from?
But Chair, no, 162 won't stay in the law. No, 162, it was an error, clearly. It can't be. These are discussions that are had. Either the court directs compensation or there is settlement. For us to, and we don't need to put it in the law. We don't need to set out these things. And then the problem is when we put it down, we have to be careful how we put it down so that we don't. Just no, Chairman, it really should not be there at all.
What's the error in your?
She wants 162 to be deleted.
Would it be? Is it 160 to 162? Is it 160 to 162?
But anytime anybody has a problem, anybody, you have the right to go to court if you really have a claim. And even outside of that, even before you file a lawsuit, what do? You retain a high-powered attorney, like some of the members over there, and then you have that attorney write on your behalf, and you enter into negotiations. Because I'm assuming this is perhaps for civil. Because remember with criminal, we already have the law, the Criminal Justice Admin Act now allows for restitution for all criminal once someone has been found guilty of an offense. There is a provision already for restitution by a victim. So this must be only in relation to civil. And I'm saying in relation to civil claims, you can have settlement negotiations between parties. If those break down or fail, there's always recourse to the court.
So, Sergeant, are you proposing that 160?
It be deleted.
160 to 162?
I know 162 has to be deleted. Let me just check 160 and 161.
161, yes.
Yes. My suggestion is 160, 161, and 162 should all be deleted.
Very well. Members, we have been so advised.
So it is a proposal to the committee that you consider, that you consider.
And I vote for your instruction.
163, Ministry.
Mr. Chairman, I wanna.
Yes.
I want to just make sure, Mrs. Bennett Campbell, that the purpose for which it was included in the first place, because we're in a position where no conviction was made as yet. This is all based on a warrant, you know, and where is it that you want to put a safety mechanism in place for the personnel who are to be, yes, and
It already exists in law.
huh?
It already exists in law. That's what this.
It already
sergeant is
exists
saying.
in law,
Yes.
yes, so, all right. No, I know, I recognize it. I just want to make sure we're not shortchanging and again putting in a position of power the potential to abuse.
Yeah. Very well.
Yes, we're fine with the deletion based on all the discussions. We don't have a problem because persons would still be able to see criminal.
163. 163 and 164 to be deleted, members. Yes.
Yes.
So we agree to that, members. 165, Ministry.
We want to revisit 165 because it's more tied to the incident notification. So we have to make that link because, so we would like to revisit this clause. Yes, because we have to tie it more to the incident notification procedure because it's not complete. So we were asked to revisit this.
Yes, you may proceed.
All right. In relation to
This is awesome power, though. I get the feeling that the ASH officer has become the FBI, an FBI agent. No, the power you're giving him here is awesome. Probably, it may be, but I just...
No, but you see, it's limited, so...
Any comment from you, Mrs. Seeley Brown? You will. Okay, fine. Very well.
There would have to be some modification. I was trying to find, I know under the Mining Act, there are usually investigations, and because I've been a couple, but it's usually where there is a death or very serious injury, that there is a formal investigation, and I've been to ones where there was a death, so the personal representatives, the deceased, so it's almost like a formal sort of hearing, usually held under the Mine Act. It's the Commissioner of Mines that usually holds that, has that hearing, and they just go through and so. But I was just trying to find if we have a sort of model to assist, because the point is this provision wouldn't be able to stay as is. So if you're going to keep something, you need a little bit of a framework around it in terms of how you conduct this investigation.
So you'd say, let's look at the mining
I'm checking to see, I'm not sure if it's there, but we will have to help and give some guidance to the ministry if they decide that they want to keep this kind of provision.
Duly noted. Mr. Baker?
Chair, in respect to disease contracted or suspected, we having to be contracted.
Where are you?
Oh,
commenting on?
same 165.
Okay, very.
So we're thinking whether or not it's accident and injury, because are the person going to be trained in that regard, the OSH officers, to conduct the disease? Some clarity
You
on
will
that.
come in as an assistant. Yes. Yes, ministry? Or Memo Long, were you?
It relates to it. My question was where do we have the definition of disease? And what does it encompass?
Occupational disease. Occupational disease is defined, and there is a whole schedule.
Yes. The psychological component being recognized?
Yes. If you look on the second schedule, it's there.
There's a long list.
While we look at the schedule, could I, through you, Chair, get from public, Mr. B, whether or not you have a similar investigative role in your act, and so that maybe another one we could look at as well? You have it, you say? Are you able to outsource the investigation? Sir, microphone.
Yes.
Are you able to outsource the investigation? For example, it just occurred that maybe in investigating infectious disease, the OSH may have limitation. They may also have the skills, but there may be limitation. Could the legislation allow for them to designate somebody to do the investigation, or to chair the investigation, or to assist?
Certainly, Senator, because we do the collaborations all the time. Once we are getting the objective to be met, that happens. But the expertise in regards to the specific situation will have to take precedence so that we get the best results. So we do have that collaboration, but we are saying depends on what we have to investigate. It would have to be the lead in terms of the Ministry of Health.
Chair, could we just ask that the ministry and the technical legal people speak with the public health people to see what's their experience and whether or not we can, instead of reinventing the wheel, we use the existing wheels with some modification maybe, but we don't need to be reinventing.
Yeah, and it goes back to a previous discussion that we had regarding certification of said risk based on the health implications. And this is where I'm trying to get at in terms of the verification of that health risk and recognize it, that the OSH officer, it is not necessarily, the OSH officer should be in a position to see to that verification rather than verifying themselves.
Mr. Mahan, you can comment on this point.
Just to remind that as we had mentioned last week's sitting, that even the Factories Act references public health, Regulation 77. So when there's any suspected cases, occupational diseases, then we would refer it to the Ministry of Health, because that is where the expertise lies. So even if we were to receive a report, because even under the National Insurance Act as well, under the Employee Injury Benefit Claim, as to be more specific, if there is a situation where even from that perspective that there's an occupational disease, and as you could have seen in the schedule under 2.4, mental health is also mentioned there, then we would have an obligation to notify the Ministry of Health and Wellness, the public health officers, for them to do that investigation.
Very well.
So just to be clear, 165 wouldn't be tying it down to the OSH personnel to be doing an investigation here.
Right, because if we get a complaint, we have to investigate it. And once we recognize it is an occupational disease related, then once we recognize that, we would now do the referral. And just as how last week when CMO made that, Ms. Seeley Brown had mentioned that we could probably put it on the face, because I was saying that we would use the same construct, what we are accustomed to in the Factories Act, where the regulations would be where that reference is made. But that is the intent. We will not be doing that investigation. It would be championed by the Ministry of Health and Wellness. The chief medical officer, who would now assign that to the medical officer for the parish. Right, Mr. Baker?
Mr. Chair, it goes back to the input needed by the health ministry at this level, and the technicalities, literally, and the input that probably we would have benefited from. But I'm trying to think of a situation where occupational disease would not relate to the involvement of a public health officer or any other health officer. Any breach would warrant a health input. So to say that it is when an occupational disease risk is there that verification is ascertained, I think I can't think of anywhere it would not. I can't think of any.
Could you expound on verification? Probably that's where I'm a bit lost.
Well,
when you say
the
verification.
investigation, whether the OSH officer is going to investigate, and whether how that verification and involvement of the public health officer, etc., etc.
Well,
at what is it automatic, or is it? With this, I am trying to ascertain in terms of the communication with the public health bodies and involvement there. It should be almost automatic.
So, Member Longmore, is it that you're saying that risk or injury, the public health should be involved?
Yes.
Because as you know, the ministry's investigation may just be limited to the risk.
Right, exactly.
But in other cases, injury may have occurred. So is it that you are saying that even if the investigation is on the basis of a risk, then the health...
Yes, yes.
Okay.
Yeah.
Yes. Just to Chair, maybe the committee could benefit if we're provided with copies of the Public Health Act, so we could see where
on the next occasion, on the next occasion, members will be provided.
Yeah, that may be helpful.
Mr. Baker, number 2.
Sir, within our public health system, there is a unit, the Occupational Health and Safety Unit, that deals specifically with these things also. And so the referral is very important so that we collaborate on dealing with these issues.
We need to have that input. We need to have that input here.
Sorry.
Yes. Sergeant, you still wish to say something?
I just realized that 165 wasn't really very clear. Is it that every single time that there is an accident or disease contracted that you're going to have an investigation? Is that the case? I wasn't sure. It says where it is expedient to do so, so I don't know. Right, and I don't think it should be left to an officer to make that determination. I think it should be at a higher level. And I think there should be more. So if there was a death that resulted, there should be an investigation. I don't think there should be a may. If there was some major disease contracted, it shouldn't be a may. Because if it means that other people could also result from it. So I don't like this where it is expedient to do so. Also, I don't like that word expedient. in terms of these kind of matters, you're not going to say it wasn't expedient to hold an investigation, so I didn't.
So you don't.
I wasn't clear on when you would hold a formal investigation, and I think it should be a lot more precise. And I think there could be some situations where you should have a formal investigation. I was going to suggest that another way to have that formal investigation would be, you see, there are so many things being dealt with under this law. You may not have any one person that can really manage that kind of investigation. So maybe the executive director could then have someone, depending on what it is, if it's a doctor that they think needs to have to conduct that investigation, get a doctor to do it. If it's an engineer, then get an engineer to do it. If you need some other skill, because this is so much wider than many other laws, you're not going to necessarily have someone with that kind of expertise. And even though, yes, you don't always have to have the expertise, it's still good for you to have that. So I would also suggest that the ministry look at Section 65 of the Mining Act, but caution you just to say that it predates the new charter, but it does have things like no person is bound to incriminate himself. So it does take into account a number of things, even for our investigation. And I would also commend the more recent, the Commissions of Inquiry Act, in terms of powers of the person who is conducting the investigation to, for instance, have persons come to as witnesses, and also for the production and so of documents, because those kind of powers you do kind of need when you have this investigation as well. So I would suggest that they look at those two things, taking into account the new Charter of Rights, and we can assist. But I still think that we would need some clarity on when you would actually hold an investigation. I don't know why the word formal is there, because is it that you're going to have an informal one and then a formal one? I don't know. Language makes a big difference. And when you decide to have this kind of provision in your law, people can challenge it. And people can say you didn't have a formal investigation. So.
Do I hear the Sultan chairman saying we need a section that deals with investigation, and it could borrow from Mining, Commission of Inquiry Act, and I would add whatever is in the public health that may be helpful. You may be familiar with it, I'm not. So to see if there's anything there, and then fashion a section on commission on inquiry.
Yes.
If that's what I mean, I support it.
Very well.
Chairman,
Yes.
I was even going a little further, because you may have had situations where it was not an accident because there was no damage, but it was an incident that could have created damage. I'll give you an example. At Noranda, you had a derail of the train, but it never caused any damage, but it warranted an investigation to take place to determine what would have been the cause for the derailment. And so you want to use, coming out of that investigation, preventative measures to be put in place in order to ensure that there's no accident or there's no recurrence. So would there be a distinction by even inserting the word incident as opposed to just accident on its own?
Mr. Simmons?
Yes. I'm just reading, well, I read the comment of the Ministry of Labour, and I looked back at Part 3, and 165, in fact, contradicts Part 3, which basically states that once you have these occurrences, it's actually a notifiable incident. And a notifiable incident actually requires an investigation. So you actually don't need Section 165 at all. Okay. But you don't need it, because you're going to have to do an investigation once any of these things occur. So as soon as they sort out Part 3, you don't need 165 at all.
Okay, very well. So, yes, so legal reform is saying that part 3, yes, once it is finalized, then there may be no need for a clause 65.
It's at pages 40 to 45, 43. Pages 40 to 43 of the bill. But once this is complied with, you really don't need 165. It doesn't give you a discretion to investigate or not to investigate.
So,
I think the investigation that is being suggested could be.
It's
yeah,
not
I don't
exactly.
know if that's a perfect place, but I don't know.
Some of the provisions don't link directly in the bill, but you can't help but take note of it, because if you look at the 4th schedule, it refers to section 133.3. They're all tied in together somehow. But I mean, that can be fixed with the draft, though. Correct.
Seems to me that arising from a notification,
could be an
there
investigation.
may be a need for 165.
That's the point.
Yeah.
An investigation.
Yeah.
No, but it's already there, is what I'm saying.
No, where?
Ministry, Mr. Mahoney, you wanted to say something in the meantime?
well, I was just going to point out that we recognize that there was a disconnect because at the incident notification, part 3,
Look
there
at
wasn't anything.
133.3. Right. 133.3B. Right. And link it to the schedule and link it also back to part 3. All the links are not in the bill itself, but they're there.
Okay, very well. Mrs. Benny Campbell or Mr. Mahon?
Well, I was just pointing out that we recognize that there were these issues, and that is why we had mentioned that we would want to deal with it under the part that is with the incident notification. So even what Senator Gale had spoken about in terms of when there's no injury, when it's a dangerous incident. If you look on the definition of under 32 of what is notifiable incident, it also makes reference to a dangerous incident. So we recognize all of that, and that would be the most appropriate place for us to deal with it, right under the part that deals with incident notification. It speaks about the notification, but then it stops there.
So you
the
want an
investigation should flow from that.
Yes. So that's
under
what
that
is,
part.
That's what is being proposed. Be proposed, yes. Mrs. Benny Campbell, you wish to say something? Ministry? Yes. Ministry? Yes. So we will come back with clause 165 and its placement. Yes.
All right, 166 to 168, it has to be amended, but we were saying that this should be more general in application, not just for powers of entry. Speaking to hindering or obstructing an OSH officer, of course it wouldn't have a reference to labor officers, so it's offenses relating. 167 is talking about holding yourself out to be an OSH officer, and 168 speaks about assault, threaten, or intimidate, or attempt to assault, threaten, or intimidate. So it's general offenses in relation to the OSH officers in exercising their powers under the Act.
Do we have any comments? 166 to 168? and the proposal being put forward by the ministry.
So just to point out to the committee
Yes.
though, that 167, the way the offense is crafted, it has to be reformulated. So normally you talk about impersonate or maybe even use their identification card or something like that. So we need to be...
So 167 is to be reformulated.
Right, because it's hold himself out to be.
It's not enough.
No, and that's not how we usually try to
Yes.
be more precise when we're dealing with criminal offenses.
Very well. Any other position? Comments?
Just want to bring out though that for all information to be before the committee, on the paper we have a person is not to hinder or stop the authority and its employees and agents in the exercise of the functions and powers of the authority under this act. This should extend to induce and attempt to induce a person. So it was wider than the USH officers themselves. 167 should be amended to clause 167(1), subclause 1 should be amended to specify that, we will be guided about the impersonation and the wording, but in relation to employees or agents of the authority. And 168 is in relation to assaulting, threatening to intimidate or attempt to assault, threaten or intimidate the employees or agents of the authority at the performance of its functions and powers under this act. So it was wider than the power of entry, which is why we were asking for it to be more generally placed in the bill.
Very well. Do we agree, members? Cecilia Brown, any comments? Or? Very well. So that now takes us, members, to part 10. And I think it's a convenient time. But your work rate today was commendable. In fact, we need other cities like this of duration and work rate.
You know what, this is not cheap. So
You tell me. He came here minutes to one. All right. So then we have next week, Monday, which is the 22nd, and we are proposing another full day sitting. Yes, lunch will be entire day next week. Yes. Yes.
we will get a similar document.
Yes, and
for
hopefully
that part.
what will happen is that for this week the ministry will dispatch the documents to the different legal teams as quickly as possible so that the comments can come, and by Friday hopefully the members, you will now have the complete document for next week's sitting. Well, yeah. Yes, so we will look into that for next week. Oh, the stakeholders' comment. She's wondering when. Yes. Okay. Yes, but yes. So members, we may have to consider sitting another day next week, in addition to Monday. I don't know if members here are up for that. Yes, but we are seeking to introduce another day. I mean, we are flexible. All right. So we'll So we will examine. Next week we will revisit
Thursday,
that proposal.
Chair,
Hmm?
sexual harassment is
Okay, fine. Yeah, well, we have him on there. All right, so this meeting is adjourned until Monday, June 22nd at 10 a.m. Member Cuthbert, seconded by Skeffrey.